with Hale and others, and the Secretary of State for Foreign Affairs and another.
The Malayan Federation was part of the British Empire until it became independent in 1957. In early 1948, UK troops were sent there in response to an insurgency. In December 1948, a patrol of Scots Guards killed 23 unarmed civilians in the village of Batang Kali in Selangor, which was one of the states of the Federation. The UK government claimed that the killing was of bandits attempting to escape and resisted calls for an investigation. 20 years later, following statements by participants in the operation that there had been a massacre and that the victims had not been fleeing, the Metropolitan Police began an investigation. It was terminated the following year by the UK government. Allegations of unlawful killing resurfaced in 1992 with the broadcasting of a BBC documentary, and an investigation was started by the Royal Malaysian Police in July 1993 and closed in 1997. In late 2008, a campaign group presented a petition seeking a public inquiry. It was refused by the UK government for reasons given in letters sent in November 2010 and November 2011. The appellants, who are related to one or more of the victims of the incident, applied to the court for judicial review of the government's decision to refuse to hold a public inquiry. The application was based on three different grounds. First, under Article 2, the right to life of the Human Rights Convention. Secondly, under the common law, by virtue of its incorporation of principles of customary international law. Thirdly, under the common law, challenging the government's refusal to order an inquiry under Section 1 of the Inquiries Act 2005. The appellants lost in the courts below, and they appealed to this court, maintaining all three grounds. The government cross-appeals, contending that the issues are not within the jurisdiction of the UK courts. This court today unanimously holds that the UK courts do have jurisdiction, and therefore rejects the government's cross-appeal. This court also holds, by a majority of 4-1, that the appellant's appeal against the refusal to order a public inquiry should be dismissed. A summary of our reasons is as follows. The jurisdiction issue. The reasons for rejecting the government's case are given in a judgment by Lord Mance, with which the other members of the court agree. First, the UK was responsible for the killings, as the Scots Guards were in the Federation in the service of His Majesty, the King, and in the interests of the United Kingdom. The powers of the United Kingdom government in the Federation were not solely referable to the domestic arrangements within the Federation, and the victims were within the British Army's control at the time. Secondly, the UK can be held responsible for not holding an inquiry now, as the actions of the UK government in this case are properly referable and characterised as being carried out in the interests of the UK, and therefore do not appear to have been transferred to the independent federation by Article 167 of the Federal Constitution. In any event, the UK government's duty to hold an inquiry could not be released to the independent federation as a matter of international law. The public inquiry issue, Article 2 of the Convention. The Convention came into force in the UK in September 1953 and was extended to the Federation the following month. The UK recognised the right of an individual to petition the European Court of Human Rights in Strasbourg in January 1966. Article 2 creates a duty on a state to carry out an effective investigation into any death which occurs in suspicious circumstances. While the Convention is generally not retrospective, Article 2 can create an obligation to investigate a death which occurred before the entry into force of the Convention, the critical date, where there are both relevant acts or omissions after the critical date, and secondly, a genuine connection between the death and the critical date. The court has unanimously agreed that the first criterion is satisfied. There has been no investigation of the killings. There was no publicly available evidence suggesting that the killings had been unlawful until the evidence that came to light in 1969 and 1970, and that evidence appears to have been compelling and to provide support for the view that the killings were unlawful. As to the second criterion, the majority of the court, Lord Mance, Lord Hughes and myself, hold that the critical date was the date when the right of petition was recognised, namely January 1966. And on this basis, as the killings occurred more than 10 years before that critical date, the Strasbourg Court jurisprudence establishes that there is no genuine connection and that the Article 2 claim must fail. Lady Hale and Lord Kerr both consider that the critical date is the date of the coming into force of the Convention, but agree with the majority, albeit for different reasons, that the appellants cannot rely on Article 2. The second ground of appeal relates to the incorporation of principles of customary international law. It's only for the past 25 years or so that international law has recognised a duty on the state to carry out formal investigations into at least some deaths for which it was responsible and which may have been unlawful. The fact that the killings occurred before this requirement became a part of customary international law means that the duty cannot be relied on. In any event, such a duty cannot be implied into the common law, given that Parliament has provided for investigations into deaths through coroners' courts, the Inquiries Act 2005, and the incorporation of Article 2 through the Human Rights Act 1998. Third ground of appeal, judicial review of the decision not to hold an inquiry. Applying the ordinary classical principles of judicial review, the majority, Lord Mance, Lord Kerr, Lord Hughes and myself, consider that the grounds for the decision to refuse to hold an inquiry, as set out in the letters of November 2010 and November 2011, informing the appellants of the decision not to hold an inquiry, were reasonable. And even if the proper standard of review is by reference to proportionality, the conclusion would be the same, namely that the decision was not disproportionate. Dissenting, Lady Hale considers that the decision of the government on this point was one which no reasonable authority could have reached, considering that the value of establishing the truth in this case is overwhelming. The appeal is therefore dismissed by a majority of 4-1, and the cross appeal is allowed.